Hello friends, year 2020, 18th February. The Calcutta High Court instructs Reserve Bank of India to consider cancelling the license of Bank of Baroda, which is one of the major public sector banks in the country. What was the reason which prompted the Honorable Court to issue such an unheard of instruction for the revocation of the license of a bank? That's what we are going to discuss in today's video. Indian Oil Corporation Limited (IOCL) had entered into an agreement with one Simplex Project Limited in 2017 for undertaking certain work at the Bongaigaon facility of IOCL. In terms of the agreement, Simplex was required to furnish a bank guarantee on account of security deposits. Afterwards, an unconditional bank guarantee was issued by Bank of Baroda on behalf of Simplex for about Rs 6.97 crore favouring IOCL. Accordingly, the contract was awarded to Simplex by IOCL. But Simplex failed to complete the construction work and failed to honour the contract signed with IOCL. IOCL then sent several letters to Simplex, but no response was forthcoming from them. Finally, IOCL had no option but to invoke the guarantee, and they did invoke the unconditional guarantee. But Bank of Baroda, the bank which had issued the guarantee, did not make the payment immediately. As per provisions of bank guarantees, the issuing bank is required to honour the guarantee by paying the guarantee amount without delay or demur. But here, the bank was asking for more time to pay the money to IOCL, the beneficiary of the guarantee. IOCL claimed that the bank must have informed Simplex because in the meantime Simplex filed a petition in the Delhi High Court to stall the payment of money. For this purpose, they relied upon Section 9 of the Arbitration and Conciliation Act 1996, by virtue of the arbitration agreement contained in the contract between IOCL and Simplex. But Simplex failed to get any favourable order from the Delhi High Court for their petition. The High Court also observed that the bank guarantee was unconditional and payment thereunder could not be avoided once the guarantee was invoked, and ruled that the bank has to pay the guaranteed money to the beneficiary. Interestingly, the bank still refused to release the payment in terms of the guarantee on the ground that the money may not have been given by Simplex to the bank. Subsequently, aggrieved by the failure of the bank to pay the amount even after court directions, IOCL was constrained to file a petition in the Calcutta High Court for a direction on the Bank of Baroda to release the payment under the bank guarantee. In the appeal, IOCL maintained that considering the conduct of the Bank of Baroda, wherein they failed to honour an unconditional guarantee despite instructions from High Court of Delhi, an appropriate order should be passed to revoke its license since it had acted in a manner unbecoming of a bank, and that to a public sector bank. The Calcutta High Court, which considered the petition of the IOC Limited, while directing the Bank of Baroda to make payment as directed by Delhi High Court, stated that the Reserve Bank of India should consider what appropriate steps may be taken against the bank, including revoking its license or the authority to carry on banking business if necessary, for delaying to honour a bank guarantee given to a third party. Bank of Baroda later approached the Supreme Court against the decision of the Calcutta High Court, but their appeal was dismissed by the Apex Court. Though the Supreme Court didn't reiterate the observations of the Calcutta High Court regarding cancellation of the license of the bank, they stated that it shall be open to the Reserve Bank to take such action as may be necessary in the facts and circumstances of the case. A bank having issued a bank guarantee owes a duty to pay the amount undertaken in the guarantee as soon as it is invoked by the beneficiary. Under no pretext can the banker either deny or defer the payment. Once the liability crystallizes, the bank is obliged first to pay. Its right of recovery arises upon payment of the guaranteed amount only. This case underlines the importance of honouring guarantees by the issuing banks without delay and demur upon invocation. The beneficiary under a guarantee is entitled to release the whole of the amount under that guarantee even if there is some pending dispute between the person on whose behalf the guarantee was given and the beneficiary. This is because the bank guarantee represents an independent contract between the bank and the beneficiary, and both the parties are bound by the terms thereof.